Welcome to Mentoring with the Masters. My name is Jennifer Kuyrkendall. I'm the Third Circuit representative for the Young Lawyers Division Board of Governors. Today I have the pleasure of speaking with Don Smith, who is with Smith, Tozian, Daniel, and Davis. Don's going to be speaking to us about bar grievances from the defense side. Don, welcome.
Thank you very much. Thanks for having me.
Absolutely. Just go ahead and start talking to us. What can you tell us about the grievance process from the defense side of things?
Well, I would tell you that first of all, my firm has been doing this since 1983, so I feel that we're experienced in this area. What I've learned over those many years of practicing and defending lawyers is that the grievance process is unusual to most of us, and that's a good thing because very few lawyers actually get involved in the Florida Bar grievance process. But it can happen to the best of us. It can happen to the most competent, knowledgeable, ethical lawyers. Complaints come from every conceivable aspect of the practice of law. Complaints come to the Florida Bar from judges, they come from opposing counsel, they come from clients, they come from opposing parties. So they can come from almost any angle, even to the best of lawyers. And to our young lawyers, and even those that are not so young, I suggest, first of all, that you not feel personally attacked by the fact that you may get a letter from the Florida Bar. The process starts generally for most lawyers when they receive a letter from the Florida Bar that tells you they have received a complaint or something has been brought to the bar's attention, because the bar need not have a complaint from someone. The bar can act upon information that was provided to it or that they uncovered in some manner, such as a news article. So the bar will send a letter to a lawyer advising him or her that some information has been brought to their attention that requires a response from the lawyer, and that the information will be attached. The lawyer has an affirmative obligation under our rules to respond to the bar. Many lawyers make an initial mistake by not responding. That's a mistake because it unto itself can be another violation, but it also is perpetuating a problem that the bar is concerned about this lawyer's conduct, and by not responding, that's not being very helpful in the bar trying to resolve the issue in favor of the lawyer. So initially, a lawyer gets a letter. It will generally come from the ACAP division of the Florida Bar in Tallahassee, which is a group of lawyers that are effectively trying to screen these initial complaints or matters of concern, trying to screen them to see if there's even enough information or a basis to go forward with an investigation. So the lawyer should first respond to that letter. The bar is gracious in giving extensions of time, particularly first extensions. So if a lawyer were to receive a letter, it generally tells you within 10 or 15 days you need to respond. They'll tell you a date certain. If a lawyer needs more time, they should certainly contact the bar and get an extension of time. To take the time to thoughtfully and completely respond. What I like to suggest to people in that position is, if you get a letter like that, take the time to sit down and respond as thoroughly and completely as you possibly can. And if you're offended or upset, bothered by the complainant, the nature of the complaint, even if it's completely untruthful, if it's factually wrong, write your complaint, respond, get it all out of your system. It's therapeutic to write it, say whatever you want to say, and then don't send that reply. Throw it away, maybe let somebody else that you trust, that's another lawyer, read it for you, but edit it so that you respond in a meaningful, complete way to the bar. Remember, the bar is doing an initial screening and analysis to see if there's even an issue. Well, the only way they know how to evaluate that is if you give them the information that allows them to do that. They're going to be operating on one side of the equation, one set of facts which has been brought to their attention, a complaint by a client, former client, whomever. The lawyer needs to take the opportunity and look at it as an opportunity to respond, rebut what's been said, add the additional facts that have been left out, correct the errors, and of course, there's an opportunity to supplement your response with documentation. So if a lawyer has the documents that can obviate the effect of the complaint or disprove an allegation, such as, I've never heard from my lawyer. Maybe the most common complaints, I'm sure the most common complaints to the bar are about a lack of adequate communication, either failure to respond to a client, failure to keep the client involved, failure to return telephone calls. Frequently, a lawyer will get a complaint to that effect and have actual documentation that he has responded to the client and communicated. Copies of letters, emails, telephone logs. There's a host of different forms of information, pleadings that have been filed on behalf of the client that were copied to the client. Provide that to the bar. Provide that to the bar so the bar can understand that this client, this complainant, whatever the nature of the matter is, doesn't rise to the level of being further investigated. A critical issue for members of the bar who receive these inquiries from the bar's office in Tallahassee is to consider whether or not there is an issue about attorney-client privilege and confidentiality. The bar rules provide, and the court recognizes, that if a client complains about their lawyer, they have effectively waived their attorney-client privilege because they placed the lawyer in a position that the lawyer must defend his representation, and that's going to involve attorney-client privilege communication. Sometimes complaints come to the bar's attention and the client isn't involved. So a client may not have waived attorney-client privilege. A lawyer has to understand that and consider what he's going to be able to say to the bar without waiving his client's confidentiality or attorney-client privilege. The bar generally can accept and understand that. So a lawyer might have to tell the bar, I'd like to tell you all the facts and give you a more thorough response, but I have to protect my client's confidentiality and attorney-client privilege, and I can't do that. It hasn't been waived. And you'll have to work through that with the Florida bar. It is my suggestion that every lawyer that's in this position have someone help them with the final draft, the final editing of their response to the bar. Someone that the lawyer trusts and has confidence in needs to give them another review, another perception of their response to see if it answers the complaint, is thorough, and the lawyer who's responding to the Florida bar must make sure that everything he or she says is accurate and truthful. One thing you don't want to find is that the investigation by the bar leads to a conclusion that what was complained about is not worthy of further investigation, but something that was said in the reply leads to other issues or was inaccurate and the facts bore that out to be incorrect. So be thorough, be thoughtful, consider all the ramifications. If in fact the bar lawyers in Tallahassee make a determination that under the facts that have been presented to them and the information that's been provided, there's no plausible way that there's been a violation of our rules, they have the authority to dismiss it, and it can be over with right there. If the lawyers determine that in that initial screening process there are issues or factual conflicts, then they are obligated to forward that on to one of the 5 branch offices that the Florida bar has in Florida, depending on the geography of the lawyer. So we have offices in Tallahassee, Orlando, Tampa, Fort Lauderdale, and Miami, Every lawyer will come under the jurisdiction, for lack of a better term, of one of those offices. The Tallahassee office can forward that down to bar counsel in one of those offices. The lawyer will then get a letter from bar counsel that it's been assigned there, and generally there's an opportunity for the lawyer to then communicate with the bar counsel in one of the branch offices, who will review it. Now they've got an initial complaint, they've got a reply, they'll probably ask some additional questions, maybe some more thorough questions of the lawyer. The lawyer should, of course, then respond to that also. That's part of the continuing obligation to reply to the bar. And again, it's helpful. It's a second opportunity for the lawyer to take the opportunity to explain the situation so that the investigation is discontinued.
One thing I think is important to point out as well is that there is no problem in going and hiring an attorney to go and represent you. It does not show any consciousness of guilt at all. So is that something that you could touch on a little bit?
Sure. Frequently I get asked that question. A lawyer, a prospective client, will ask me if they hired me or someone else in my firm or some other lawyer to write the reply and reply to the Florida bar for them. Is that going to evidence to the bar that there must be something amiss, there must be a violation here because they went out and hired a lawyer? I think 30 or 40 years ago, that probably might have had some relevance or was a relevant question. No longer so. The bar receives responses on behalf of other lawyers, from other lawyers frequently now. I think that it has no bearing on the matter one way or the other. And generally the bar is very comfortable in accepting the representations by lawyers on behalf of other lawyers that what they're telling them is accurate, because hopefully we're going to try to make sure that everything is accurate. So there's no prejudice to them if they choose to do that.
All right. Any other parting words of advice you would give to a young lawyer or any age lawyer that's received a grievance against them?
My parting thoughts would be, don't be offended. It can happen to the very best of lawyers. Think like a lawyer. Treat it as something that's serious, but there is probably going to be a resolution to it. So be thoughtful, be complete, be absolutely truthful, and be absolutely accurate. And the chances are that that will resolve your matter without any further investigation by the Florida bar. The huge majority of complaints and matters that come to the bar's attention never go even to a grievance committee or to the probable cause level.
All right. Well, thank you so much for being here. You've certainly been very informative on this whole process and procedure. And do check back regularly with the Mentoring with the Masters video series for all sorts of videos that will affect your practice. Thank you for watching.